Welcome to today's program, Legal Ethics, The Dirty Dozen, Part 3. My name is Zach McGee. I'm a Senior Vice President, Business Affairs for Sony Pictures Entertainment. Prior to joining Sony Pictures, I was an in-house lawyer at NBC Universal, and before that, I was a lawyer at Davis Polk. I've been writing and speaking on legal education topics for the past 20 years, including having taught a course on legal ethics at Pepperdine Law School. As you might expect, I'm speaking today solely on behalf of myself, and my views don't reflect those of my current or any former employers or institutions with which I've been affiliated. Today's program is a legal ethics program focusing on the Dirty Dozen, by which I mean the 12 dirtiest, most unethical lawyers in the history of lawyering in the United States. In Part 1, we covered Bill Larack and Mel Weiss of Milberg Weiss, former Illinois Governor Rod Blagojevich, former Vice Presidential Chief of Staff Scooter Libby, and former President Bill Clinton. In Part 2, we covered former Attorney General Alberto Gonzales, former White House counsel John Dean, Roy Cohn, and Clarence Darrow. Now we're ready to reveal the top, or really the bottom, 3 lawyers on our list of the 12 most unethical lawyers in United States history. Number 3 on our list is Johnny L. Cochran Jr., who of course is famous for having been lead counsel for O.J. Simpson in his 1994 trial for the murders of Nicole Brown and Ron Goldman. The O.J. Simpson case is often referred to as the trial of the century, and Cochran led a dream team of high-priced defense lawyers who won that case for O.J., resulting in a complete acquittal for a man that most people believe killed Nicole Brown, the mother of his 2 young children, and her boyfriend, Ron Goldman, by slashing their throats in a horrific double homicide. We are going to spend most of our time talking about the unethical conduct Cochran and his team committed in the O.J. case. But first, we should say a little bit about who Cochran was, apart from his starring role in The People versus O.J. Simpson. According to Cochran, he decided to become a lawyer after seeing how lawyers could be a force for good, following Thurgood Marshall's landmark legal victory in Brown versus the Board of Education. As Cochran was fond of saying, he worked not only for the OJs, but also the no-Js, meaning people who didn't have money or weren't famous. It is true that Cochran handled several high-profile police brutality cases where he secured large monetary awards for African Americans who were killed or beaten by the police in the 70s, 80s, and 90s, including Ron Settles, a black college football player who was killed by the LAPD, and Abner Louima, a Haitian immigrant who was sodomized with a plunger by the NYPD while in custody. Cochran also became the first African American assistant district attorney in Los Angeles County when he joined the office in 1978, taking a pay cut to do so, and saying at the time that he hoped to change the system from the inside. While Cochran fought police brutality and did a stint in public service as an ADA for most of his career, Cochran built a legal empire. At one point, his law firm employed hundreds of lawyers and had offices in 15 states, and great wealth. He was reportedly worth at least $25 million at the time of his death in 2005, defending the rich and famous in criminal cases, including Sean Puff Daddy Combs, Michael Jackson, Tupac Shakur, Snoop Dogg, and many others. It's hard to find a social justice or groundbreaking legal precedent angle to these cases. For example, Cochran won an acquittal for former child actor Todd Bridges, who played Willis on Different Strokes, after he was accused of attempted murder for shooting his crack cocaine dealer. Not sure representing former child stars as they're circling the drain is a good use of time for someone as talented as Cochran, who could have been a lot more like his hero Thurgood Marshall had he chosen to do so. Cochran is perhaps best known for his famous line from his closing argument in the O.J. case, "If the glove don't fit, you must acquit." As we will learn in a moment, Cochran and his co-counsel F. Lee Bailey goaded prosecutor Christopher Darden into asking O.J. to try on the bloody gloves in open court, and, whether due to shrinkage from the blood, skillful acting on O.J.'s part, or a combination of the two, the gloves appeared to be too small for O.J.'s hands. Darden later would accuse Cochran of tampering with the gloves, although there is no evidence to support that charge. In Cochran's own words, quote, "It was one of the worst humiliations I have ever seen a prosecutor suffer in front of a jury. It was, I told my jubilant colleagues back at the office that night, perhaps the most expensive piece of remedial legal education I had ever seen. They all laughed and then laughed again when someone quipped that, all things considered, Darden has helped the defense team more than Robert Shapiro, end quote, who was one of Cochran's co-counsel in the case. For his part, Shapiro fired back at Cochran during the trial, at one point famously accusing him of not only playing the race card, but dealing it from the bottom of the deck. We'll consider in a moment whether it was ethical for Cochran to play the race card in the O.J. trial, or for Cochran and Bailey to goad Darden into making this colossal misstep with the bloody gloves. But suffice it to say that Cochran's tactics resulted in a line, "If the glove don't fit, you must acquit," that made him famous, outlives him to this day, and probably was a major factor in the jury's decision to acquit O.J. For those of us who are old enough to remember it, the O.J. trial was a legal circus, the likes of which had never been seen before, mostly due to the fact that every aspect of the case, from each bombshell disclosure of a new witness or piece of evidence to the trial proceedings themselves, was televised. What this also meant is that the actions of the lawyers in the case, Marcia Clark, Christopher Darden, and Bill Hodgman as the prosecutors, and Cochran, Bailey, Shapiro, Gerald Ullman, Alan Dershowitz, Barry Scheck, and Carl Douglas for the defense, as well as those of Judge Lance A. Ito, were laid bare for all to see on a daily basis. And there was a lot to see, as we will get into in a moment. The upshot was that whatever you thought about O.J.'s guilt or innocence, chances are you were outraged by the conduct of the lawyers in the case for one thing or another. In fact, the California State Bar received over 300 complaints about the conduct of the lawyers in the O.J. trial from the public and members of the judiciary. A State Bar official noted that, quote, "It's fair to say that every lawyer who appeared on television during the trial was the subject of some kind of complaint. People didn't like what they were seeing," end quote. Prompted by these complaints, and after the trial ended, the State Bar undertook an investigation carried out by a team of bar attorneys and staff members who sorted through trial transcripts and videotapes and spoke with a number of witnesses. What was the upshot of the State Bar's lengthy and unprecedented investigation? It recommended public reproval of Douglas for abusing the subpoena power and Scheck for practicing law in California without a license. Talk about a dud of a report. No discipline of any kind was recommended against Cochran, Bailey, Clark, or Darden, despite what, in my humble opinion, were some pretty spectacular ethical violations committed by these lawyers. It's like nailing the murderous Al Capone for tax evasion, but instead of sending him to prison, you give him a suspended sentence and let everyone else in the gang off the hook. What's worse, the intense media spotlight that covered the O.J. trial made these ethical violations even worse in terms of their effect on the public's opinion of the legal profession. I'm sure the whole affair left many in the public to think, if this is what ethics means to the high-powered lawyers in the trial of the century, the whole concept of legal ethics must be a sham. Now wait a minute, you might say, if the California State Bar cleared Cochran as well as Bailey, Clark, and Darden of ethical violations in connection with the O.J. trial, who are you to say they behaved unethically? And how do you get away with putting Cochran on a list of the 12 least ethical lawyers in the United States when he was never found to have violated the ethics rules, even after the State Bar investigated him? I would say that you can judge for yourself after you hear what these lawyers did, whether they acted ethically or not, and whether you would have felt comfortable engaging in the same conduct had you been in their shoes. I also would point out that the California State Bar investigates up to 7,500 complaints a year and chooses to take action in less than 2,500 of those cases, which is not great odds for the public and not bad odds for the ethically challenged. Maybe the State Bar, just like everyone else in the country, was sick and tired of the O.J. case at that point and couldn't bring itself to file charges against any of the lawyers given the fight that would have ensued. Still, I think the State Bar got it completely wrong with respect to its findings, although I will concede that other commentators, like Professor Erwin Chemerinsky, disagree with me on this point. In any case, just as the not guilty verdict in the O.J. case isn't the same thing as finding O.J. innocent of murdering 2 people, and as most people know, O.J. was found liable for killing them in a later civil trial with a lower standard of proof, the State Bar's decision not to charge Cochran with violations of the legal ethics rules doesn't mean that he acted ethically. And I also think it makes a difference when you violate the ethics rules in a high-profile case where, through your actions, you set a brutal killer free, and by doing it in the media spotlight, you taint forever the public's opinion of what lawyers do and how we should act. Just like Alberto Gonzalez, who made all of us less safe by authorizing torture and illegal wiretapping while he was the Attorney General of the United States, Cochran deserves to be on our list for what he did in the O.J. trial, even if he, like O.J. himself, wasn't convicted of any wrongdoing. Let's take a look at some of the worst things Cochran did, and I'll make my case that his conduct violated the ethics rules. Misconduct by Cochran and the other lawyers in the O.J. trial can be grouped into 3 buckets. Number 1, improper statements to the press. Number 2, violations of discovery rules. And number 3, improper conduct during the trial. We'll discuss each of these in turn. Improper statements to the press came in 2 general forms. 1, improper statements criticizing Judge Ito, and 2, improper statements intended to influence the public and/or the jury. Few of us in our careers have had an opportunity to be involved in a case that attracts enough media attention for us to publicly criticize a judge's rulings and have anyone in the media pay any attention to it. Of course, the O.J. trial was the exact opposite. Any lawyer and practically anyone else who was involved in the case could command the media's attention instantly and practically at will. This led to a lot of public statements being made by the lawyers on each side, in many cases, if only out of a perceived need to respond to something being said in the media by the other side. While Cochran and the defense team fought bitterly with Marcia Clark and the prosecutors, one thing they agreed on was that Judge Ito at various times made rulings that they believed were terrible, and they were not shy about sharing those feelings with the media. For Cochran's part, his most strident public statements were made following Judge Ito's decision to exclude almost all of the tapes of statements by LAPD Detective Mark Furman to journalist Laura Hart McKinney, in which Furman repeatedly used the N-word and bragged about engaging in official misconduct. Cochran blasted Judge Ito's ruling as, quote, outrageous, specious, and unspeakable, end quote, and called his decision, quote, doctored, tortured reasoning, end quote. For her part, after Judge Ito sanctioned her for coming late to court, Clark railed against the ruling, calling it, quote, outrageous, vindictive, petty, and uncalled for, end quote. Were these statements by Cochran and Clark unethical? Although it may surprise many of you, the answer is clearly no. As the California State Bar found, these statements, although ill-considered, were protected by the First Amendment. Judges are public officials, and the Supreme Court repeatedly has held that the First Amendment requires that there be robust and open debate about the conduct of those holding public office. In Standing Committee on the Discipline of Yagman, the Ninth Circuit held that a lawyer cannot be disciplined for speech critical of a judge, no matter how strident, unless the attorney knowingly makes false statements of fact. Here, the statements by Cochran and Clark clearly were not statements of fact, but rather of opinion, and thus would not have been actionable under the standards set out in Yagman. So, Cochran and Clark get a pass on nasty comments they made to the media about Judge Ito and his rulings, although I think most lawyers would not approve of such conduct or engage in it themselves. What about Cochran's public statements intended to get information, and arguably misinformation, to the jury outside the courtroom? Even before the trial began, Cochran and the defense team sought to use the media to influence the pool from which prospective jurors would be selected. One way they did this was by ensuring that the charges against O.J. were subject to a public preliminary hearing and not presented in private to a grand jury. As Shapiro put it, the televised preliminary hearing was nothing less than a battle for the hearts and minds of the jury pool. Clearly, there is nothing unethical about availing oneself of the right to have a public preliminary hearing in lieu of a grand jury where the law allows it, but Cochran and the defense team didn't stop there. As most people know, once the trial began, the jury was sequestered and instructed not to read or watch any news reports of any kind. However, because the jury was sequestered for many months, Judge Ito did permit the jurors to receive conjugal visits from their spouses on weekends, and of course instructed the jurors not to discuss the case with their spouses during those visits or otherwise. Cochran and his colleagues took advantage of this schedule by holding what they privately referred to as Pregnant Friday press conferences, in the hope that some of the information they had just put out to the media on those Fridays, including their most explosive claims of racism and misconduct by the LAPD, would make its way to the jurors as pillow talk, shared with them by their spouses during these weekly conjugal visits. Was that ethical? Of course, there was no law or ethics rule against holding press conferences on Fridays, But Model Rule 8.4 provides that lawyers shall not engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Model Rule 3.4c prohibits lawyers from knowingly disobeying an obligation under the rules of a tribunal except for an open refusal based upon an assertion that no valid obligation exists. In California, Business and Professions Code Section 6103 provides that a willful disobedience or violation of an order of the court requiring him to do or forbear an act connected with or in the course of his profession, which he ought in good faith to do or forbear, and any violation of the oath taken by him or of his duties as such attorney constitute causes for disbarment or suspension. I think you can make a good case that holding press conferences where you put out misinformation, or at the very least, information that the jury was not permitted to hear in court, in the hope that it will make its way to jurors via their spouses in willful violation of the court's sequestration order, constitutes a violation of these rules. At a minimum, I think it's a good example of dodgy conduct that Cochran enthusiastically engaged in because he wanted to win, justifying it along the way as his ethical duty to engage in such conduct because it wasn't expressly prohibited by the ethics rules. But as we learned, that is not the standard that governs lawyers in California or elsewhere, and Cochran is properly faulted for engaging in conduct that violates the ethics rules, even if the violation isn't as black and white as it might otherwise have been, simply because Cochran and his colleagues were clever about how they got around Judge Ito's sequestration order. My guess is that if you asked 100 lawyers whether they would have done what Cochran did here, 95 would say no. Even among criminal defense lawyers, I would guess that number would be at least 80. The next category of misconduct by Cochran involved violations of the discovery rules. You might say that discovery rules get violated all the time by criminal defense lawyers, but also by civil lawyers, and that it is up to the court to determine the appropriate sanction for such violations. Unless the conduct constitutes a violation of a discovery order, which would trigger Model Rule 3.4c and California Business and Professions Code Section 6103, you might think that it would not give rise to an ethical violation. You might be right in normal circumstances, but what Cochran and the other lawyers in the OJ trial did in terms of knowingly and repeatedly violating the discovery rules to advance their position and prejudice the other side absolutely warrants a finding of unethical conduct on both sides. Surely, each side would point the finger and say they started it, but an ethical violation by opposing counsel is never a justification for engaging in unethical conduct yourself. So what discovery rules did Cochran and the defense team violate? As we only have 1 hour for this program, we'll just hit some of the highlights. While the defense team pushed the prosecution to bring the OJ case to trial and disclose the evidence against him as quickly as possible, they repeatedly held back their own evidence and witnesses for as long as possible. For example, Cochran's main forensic expert, Dr. Henry Lee, had made notes related to his findings that Cochran and Scheck believed revealed too much, so they withheld these notes from the prosecution for more than a year. While Judge Ito admonished Cochran and Scheck, promised significant monetary sanctions, and granted the prosecution extra time to prepare, he ultimately allowed Dr. Lee to testify. In another example, Scheck resisted disclosing demonstrative exhibits he had prepared that made the case for the first time that some of the blood sample taken from OJ was missing, even though disclosure of the exhibits prior to using them in court clearly was required by the discovery rules. When Douglas protested to Cochran and Scheck that we're sandbagging them, we'll catch hell for this, Cochran replied, "It's about the client, it's not about you, it's for the client. You'll have to fall on your sword. Go and do it." In probably the most dramatic violation of the discovery rules, just as the trial was set to begin, prosecutor Bill Hodgman protested the last-minute addition of 34 witnesses to the defense's list, noting that most of them should have been disclosed 5 months earlier. 2 days later, when Cochran presented his opening statement, he told the jury about 13 other witnesses who still had not been included on the defense's list. Shaking with anger, Hodgman protested again, and later that day he was hospitalized with chest pains. Although Hodgman did not have a heart attack, he never returned to his active role in the courtroom after the incident involving the defense's witness list. While Cochran denies it, 2 other accounts of the trial report that he and Douglas joked about Hodgman's hospitalization when they learned of it, saying something to the effect of, "1 down, 2 to go." For his part, Judge Ito took the unprecedented step of granting the prosecution an additional opening statement because the defense had failed to disclose these witnesses. Is it ethical to break the discovery rules so flagrantly that you put opposing counsel in the hospital? Again, I think the cold, calculated, and repeated nature of the violations committed by Cochran and the defense team prove that their conduct was unethical and that they should have been sanctioned for it by the California State Bar. In the interest of equal time, Clark and Darden were found to have violated the discovery rules too, albeit not with the same frequency as Cochran and the defense team, but clearly with the same motive to prejudice their opponents. For example, the prosecution was denied the use of important evidence that established the uniqueness of fibers from O.J.'s vehicle that matched those at the crime scene, because they had failed to disclose this evidence to the defense team. I think it does make it worse for the public's perception of lawyers if both sides are engaging in unethical conduct rather than just one side, because it shows a universal lack of respect for and enforcement of the legal ethics rules. I'm sure Clark and Darden felt justified in fighting fire with fire, but as we know, that doesn't excuse their conduct under the general legal ethics rules that apply to all lawyers, or under the special rules that require prosecutors to do justice and not just to secure convictions in particular. Finally, we take up Cochran's improper conduct during the trial. Again, if this were a 10-hour program, we'd probably get through most of it, but since we're doing only 1 hour today, we'll just cover the highlights. Let's start first with Cochran's conduct intended to play upon the weaknesses of the prosecutors as the strain of the trial was getting to them. Here's what Cochran said about that. Quote, "Marcia, I could see, was simply wearing down under the strain of an unsettled personal life. Darden's temper was wearing thinner. We began to look for ways to exploit that, and one soon presented itself." End quote. Cochran continued, quote, "I made a few conversational feints at Darden over the issue to put him on edge. It was one of those days when he clearly seemed rattled. But I knew the one person he couldn't stand taking anything from was Lee Bailey. Lee and I huddled. One more push and that young man might just go over the edge, I suggested. During a recess in the testimony, Lee walked casually over to Darden and said, 'You've got the balls of a stud field mouse.' 'What are you on my back for now?' Chris replied with one of his patented snarls. 'If you had any nuts at all,' Bailey sneered, 'you'd make O.J. try on that glove. If you don't have him try on the glove, we will.' And so Darden did. Of course, we all know what happened next. But is it an ethical violation to exploit your opponent's weaknesses or to goad him or her into doing something foolish? I think the answer to that is clearly no, because there is no general duty imposed upon lawyers to practice law in good faith. California leads the country in promulgating some aspirational civility guidelines that advise lawyers that their communications should at all times reflect civility, professional integrity, personal dignity, and respect for the legal system. An attorney should not engage in conduct that is unbecoming a member of the bar and an officer of the court. These guidelines cite as examples of communications that are disfavored include, among other things, disparaging the intelligence, integrity, ethics, morals, or behavior of the court or other counsel, parties, or participants when those characteristics are not at issue, disparaging another's personal characteristics in terms of race, class, background, etc., and using hostile, demeaning, or humiliating words. While admirable, California's civility guidelines are just that, guidelines, and lawyers cannot be subject to discipline for failing to follow them. It's a slippery slope to say you should not play upon an opponent's tendency to be quick to anger when nobody thinks you have to take it easy on an adversary who isn't as smart or prepared as you are. The adversary system is just that, a contest between adversaries, and not an impartial search for truth where you have an obligation to help the other side present its case. As such, I don't think we can say that Cochran or Bailey violated the ethics rules for taking advantage of Darden in the way that they did, but I don't think it was praiseworthy either. And I certainly wouldn't have done something like that myself, would you? Okay, so enough with the maybe unethical conduct or the what kind of lawyer do you want to be stuff. Let's turn now to some clear ethical violations by Cochran and the O.J. defense team. First, let's start with Cochran's stint as an interior decorator. At one point in the trial, the jury was allowed to visit O.J.'s home on Rockingham Avenue. But the home the jury saw was very different from the one O.J. lived in at the time of the murders, thanks to the work of Cochran and the defense team. According to Larry Schiller's account, quote, "Rockingham is now sparkling, the furniture arranged for maximum effect. O.J. wants a fire in each fireplace. $1,000 worth of flowers have been ordered. The American flag must fly on the flagpole out front. A nude portrait of Paula Barbieri vanishes from its spot near the fireplace in O.J. Simpson's bedroom. There will be no pictures of white women in O.J.'s bedroom. A silver-framed picture of O.J. and his mother goes on the bedside table. The white women on the walls have to go, and the black people have to come in. All along the wall on the curving stairway, pictures are taken down. We've got to have pictures of his family, his black family up there, Cochran says. Kardashian has photos enlarged at Kinko's, then framed nicely. The jurors won't notice that they are color photocopies. Cochran wants something depicting African American history. What about that framed poster from my office of the little girl trying to get to school, he asks. Johnny means Norman Rockwell's famous 1963 painting, The Problem We All Live With, in which a black grade school girl walks to school surrounded by federal marshals. After a walkthrough of the Rockingham estate just before the jurors tour it, Marcia Clark is angry. She complains about the fires. Judge Ito orders them extinguished. To Cochran's surprise, Clark doesn't notice the Rockwell reproduction at the top of the stairs. Are you kidding me? You take down a nude portrait of Paula Barbieri and you replace it with an iconic Norman Rockwell painting of the civil rights movement? You swap out photos of white women with photos of his black family that are really just color copies enlarged at Kinko's to fit the new frames. You arrange to have the American flag flying out front. But wait, you say, it's OJ's house and he wants to change the decor. He has a right to do that. Sure, but if you use those changes in an effort to mislead the judge and jury, you've committed an ethics violation. As we know, Model Rule 8.4 provides that lawyers shall not engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Model Rule 3.3 prohibits a lawyer from knowingly making a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer, or offering evidence that the lawyer knows to be false. I'm sure whether it's a false statement of fact or false evidence, but I'm pretty sure that the Rockingham redecoration project clearly qualifies under one of these provisions. In a post-verdict interview, Cochran, of course, denied any role in this. Quote, Larry Schiller wrote in the book that when the jury was taken to O.J. Simpson's home to examine it, your staff was in that house before the jury got there, taking down certain pictures and putting up other pictures. For example, a picture of Martin Luther King, which supposedly came right out of your house. Pictures of girlfriends that he may have had down from the wall to make it look more like a home than perhaps a bachelor pad. True or not true? Cochran, absolutely untrue. Absolutely untrue. My role in this case was to coordinate the evidence. I was concerned with the evidence. I never went out to that house and looked at any photographs. I had nothing to do with that. O.J. Simpson had a housekeeper or a secretary. I, nor anyone in my office, went out there to do anything, end quote. Given the level of control Cochran exercised over O.J.'s defense, there's no way he wasn't involved in this down to the last detail. For engaging in such dishonesty intended to mislead the jury, Cochran clearly violated Rules 8.4 and 3.3. We've saved the worst for last, which was Cochran's decision to play the race card in the O.J. trial, arguing both in court and in the media that O.J. had been framed by racist LAPD officers with no direct evidence of any kind to support that claim, while, at the same time, impermissibly using race as the key criterion he used to select the jury in violation of the law and ethics rules. Even if we were to give Cochran a pass on arguing that O.J. was framed by racist cops, given the LAPD's history and despite a lack of evidence to support that claim, his use of race to select the jury was clearly illegal and unethical. In Batson v. Kentucky, the Supreme Court held that prosecutors may not consider race in selecting a jury, and in Georgia v. McCollum, the court extended that same prohibition to defense counsel. Cochran must have been absent the day they taught these cases in law school because he used race, specifically his desire to pack the jury with black women, as his key criterion for picking the O.J. jury. Cochran's jury consultants knew that black women were most likely to vote for acquittal because they tended to discount the domestic abuse evidence, and to a lesser degree because they tended to view white women like Nicole Brown and even Marcia Clark more unfavorably. When jury consultants working for Cochran asked the members of a focus group to rank on a scale of 10 the sympathy they felt for various trial figures, the black women all gave O.J. Simpson 9s and 10s. Nicole Simpson scored a 7, a 5, and a 3.9. When asked to describe Robert Shapiro with one word, black women used adjectives like clever and smart. Their words for Marcia Clark were shifty, strident, bitch, bitch, and bitch. So Cochran was clear on his goal: get as many black women as possible on the jury. And he pursued that goal with a single-minded focus. Here's how Lawrence Schiller described what occurred in his book, American Tragedy. Quote, "We'll be in great shape if we can get 4 blacks," Johnny had always said. Now they have 6. More black jurors than we ever dreamed of, Sean Chapman says. But Cochran isn't satisfied. We've got to kick off this one, he says. No one can believe he wants to take the risk. If Cochran excuses a juror, that will give the prosecutors another shot. They could lose a black juror over it. But Cochran is leading now. He rises. Defense will ask the court to thank and excuse juror number 1187. Sure enough, Marcia Clark takes out juror 1164. Quickly, Shapiro excuses another. The exchanges kept things relatively even. Time to quit? Cochran raises his head and checks the group waiting outside the jury box. Throughout the day, deputies have been bringing potential jurors into the courtroom well before their turn to be questioned. Now Cochran sees that the jurors in waiting are mostly black. Defense will ask the court to thank and excuse juror number 1040. Clark and Hodgman huddle a while, then accept the new panel. The team can hardly contain itself. The prosecutors have now accepted a jury with 7 blacks. We have 7, Sean is jubilant, but Cochran won't stop. Eff it, he growls. I'm getting that lady off. Johnny, we have to accept, Douglas urges. This is better than we ever imagined. Cochran wins. Luck be a lady tonight. Cochran sends another juror home. A black woman steps in to take the empty seat. Marcia Clark rises. Your Honor, the people accept the jury as presently constituted. Now it's time to stop. 8 black jurors. Time to pocket the dice. Cochran turns to Douglas and Chapman with a wide grin. You guys wanted me to give up when we had 6. You guys were scared. Douglas agrees. You're right, Johnny. We were ready to wimp out with 6. You kept going, and we got 8. Walking back to the holding cell, Simpson too was excited. If this jury convicts me, he jokes to Douglas, maybe I did do it. To add insult to injury, Shapiro famously accused the prosecutors at the time of an insidious effort to try to get black jurors removed for cause because they are black, because they have black heroes, and O.J. Simpson is one of them. Needless to say, there is no credible evidence that the prosecutors improperly used race in jury selection, although both sides were undoubtedly aware that African Americans were more likely to favor O.J., whereas we have clear evidence that Cochran and the defense team impermissibly used race to pick their jury, while at the same time decrying the prosecution of O.J. as racist. At the end of the day, the O.J. jury had 9 African Americans on it, of which 8 were women, which means that Cochran clearly won and the prosecutors and the country clearly lost. Because Cochran and the defense team violated the Batson rule as it applies to defense counsel, Cochran was guilty of violating Model Rule 3.4c and California Business and Professions Code Section 6103. Number 2 on our list is Cochran's co-counsel in the O.J. case, F. Lee Bailey. Bailey deserves to be on our list for what he did in the O.J. case, but Bailey engaged in so much other misconduct during his long career that we need not rely on the O.J. case to justify putting him on our list. Before we examine what got Bailey disbarred, let's spend a few minutes talking about who Bailey was and what made him famous as a lawyer even before he joined the Dream Team defending O.J. Bailey was born in Massachusetts, and by all accounts, he was a gifted student. He attended Harvard College until 1952, when he dropped out to join the Marines. After serving as an officer and naval fighter pilot, Bailey returned to Massachusetts to attend law school at Boston University, where he graduated first in his class with the highest grade point average in the school's history. He instantly rose to fame when he won a new trial for Sam Shepard, who had been convicted of murdering his wife in a crime that became the basis for the movie The Fugitive, starring Harrison Ford. Bailey successfully argued to the United States Supreme Court that Shepard had been denied a fair trial, and upon his retrial, Bailey won him an acquittal. Next, Bailey successfully defended Captain Ernst Medina in his court-martial proceeding, where he was accused of allowing his men to kill civilians in what became known as the My Lai Massacre during the Vietnam War. On March 16, 1968, U.S. Army soldiers committed a mass killing of between 347 and 504 unarmed civilians, including men, women, children, and infants in South Vietnam. It's unclear to this day whether Captain Medina should have been acquitted for his role in the massacre. Although he denied killing civilians himself, he admitted to shooting one woman who he had found hiding in a ditch, even though she had raised her hands to surrender, because Medina thought she was carrying a grenade. I'm no military expert, but I'm not sure how she could have been detonated a grenade with both of her hands raised. Whether Bailey succeeded in getting Medina off when he should have been executed for his role in a famous genocide is up for debate. Suffice it to say, Bailey's fame as a criminal defense lawyer only grew as a result of his victory. For the lawyers on the O.J. defense team, representing a man who committed a brutal double homicide was likely the biggest monster they had ever had as a client. For Bailey, who represented the man at the center of the My Lai massacre, O.J. was a distant second. Like most famous lawyers, Bailey didn't win all of his cases, and his next high-profile case handed him a big defeat, although he ended up saving his client from a possible execution in a related case. In 1976, Bailey defended newspaper heiress Patty Hearst, who committed armed robbery after having been kidnapped by the Symbionese Liberation Army, an oddball radical group that committed several robberies in the 1970s. Hearst was convicted, and there were complaints that Bailey mishandled certain aspects of the trial, including his closing argument, during which Bailey appeared to be drunk, so drunk in fact that he spilled a glass of water on his pants during the argument. That's pretty bad. You're arguing to the jury that your client shouldn't be convicted of armed robbery for her role in a high-profile case, and you look like a preschooler who just peed himself on the monkey bars. This would be the first of many references to Bailey having had a serious drinking problem, including an arrest for drunk driving in California, which Bailey contested and won. That experience led Bailey to write a book about how to beat DUI cases, provocatively titled How to Protect Yourself Against Cops in California and Other Strange Places. Through the O.J. trial, many people noticed that Bailey kept a silver flask on the defense table, although Bailey insisted the flask contained only coffee. Although Patty Hearst was convicted and served 2 years in prison, the remainder of her sentence was commuted by President Jimmy Carter in 1977, and she was given a full pardon by President Bill Clinton in 2001. For his part, Bailey also was able to negotiate a plea deal for Hearst in a related armed robbery case involving the Symbionese Liberation Army, where Hearst faced the death penalty due to the application of the felony murder rule. Bailey's plea bargain gave Hearst immunity in that case in exchange for testifying against the other defendants. Before we discuss the DeBach case, which is the one that ultimately got Bailey disbarred in Florida, reciprocally disbarred in Massachusetts and in Massachusetts federal courts, and denied the right to become a member of the bar in Maine, we need to talk a bit about Bailey's now famous cross-examination of Mark Fuhrman in the O.J. trial. As was par for the course in the O.J. case, Bailey held a press conference prior to his cross-examination of Fuhrman where he stated, quote, "Any lawyer in his right mind who would not be looking forward to cross-examining Mark Fuhrman is an idiot," end quote. And Bailey's cross-examination did not disappoint. During the examination, he got Fuhrman to testify, Marine to Marine, that he never used the N-word to describe black people during the last 10 years, a claim that the defense team was able to refute using the portion of the Laura Hart McKinney tapes that Judge Ito allowed into evidence. The next time Fuhrman appeared before the jury in the O.J. case, he was forced to take the Fifth Amendment on every question he was asked, lest he be held to have waived his right not to testify in a future case against him for perjury. Seizing on Fuhrman's invocation of the Fifth Amendment against self-incrimination, Bailey and the defense team seized on this opportunity to ask Fuhrman questions like, "Did you plant or manufacture any evidence in this case?" To which Fuhrman was forced to take the fifth, rather than simply answering no. Many people believe that Bailey's cross-examination of Fuhrman, along with the prosecution's blunder in having O.J. try on the bloody gloves, were the key moments in the trial that led to his acquittal. Turning now to the case that got Bailey disbarred, in 1994, Bailey represented Claude DeBach, a very wealthy marijuana dealer. For any millennials who are watching this program, yes, there was a time in America when marijuana was illegal and people could go to prison for a very long time for growing it. You also could make a whole lot of money by growing it, which oddly is still true today. In addition to sending you to the big house, prosecutors also could seize all of your assets if they could prove they were involved in the drug trade. The feds had DeBach dead to rights, and so Bailey's only move was to negotiate a plea deal for him in the hope of avoiding serious jail time. The plea deal involved DeBach turning over all of his assets so they could be sold and the proceeds turned over to the feds. After all of his assets were liquidated, the judge in the case would determine how full DeBach's cooperation had been in deciding his sentence. So, DeBach had a very real interest in making sure that all of his assets were disclosed and property liquidated so that he could receive an A+ for cooperating at the time of his sentencing hearing. Unfortunately for DeBach, Bailey had some ideas of his own for what to do with some of DeBach's assets, particularly the stock that he owned in a company called Biochem. DeBach's Biochem stock at the time was worth about $6 million, and for various reasons, DeBach wasn't able at the time to sell the shares. As a result, Bailey was appointed by the court to hold the Biochem stock in trust until such time as it could be sold, and to use the stock as collateral to generate funds that could be used to maintain several mansions DeBach owned in France until they too could be sold. Although a client transferring assets to his lawyer to hold in trust until they could be sold is unusual, it was clear at the time the purpose for which these assets were being transferred to Bailey, i.e., that he was holding them in trust for DeBach and the court, and that Bailey was not supposed to use them for his own benefit. At the risk of spoiling the surprise, Bailey didn't exactly do that. First, Bailey used the stock as collateral to borrow almost $4 million, which he used for various purposes, including paying his business and personal debts. Bailey continued to do this even after the judge in the case, Judge Maurice Paul of the Northern District of Florida, issued orders removing Bailey as DeBach's counsel, ordering him to return the stock immediately and to provide a full accounting of the expenditures to the court. Bailey also improperly delayed the sale of the French mansions so that he could use them for his own benefit. Bailey did all of this despite the obvious conflict of interest this created between his client, who wanted nothing more than his assets to be sold quickly and at full value to bolster his case for cooperation at sentencing, and himself. To make matters worse, Bailey lied about his knowledge of the two court orders under oath, and then wrote an improper ex parte letter to Judge Paul in violation of court and ethics rules. Basically, there was nothing about Bailey's handling of the DeBach case that was ethical, and the Florida State Bar came down hard on him for his conduct. So what was Bailey's defense to all this? Because Bailey was to be paid his fee out of some of DeBach's assets, Bailey claimed that he was entitled to retain the $4 million that he borrowed against the Biochem stock as that fee, and that because he was never ordered to hold DeBach's assets in trust, he could not be held liable for commingling or mismanaging those assets. I guess Bailey thought he had an argument because during the period in question, DeBach's Biochem stock had increased in value from $6 million to $10 million, leaving $4 million of gain. But Judge Paul never authorized Bailey to take any fee out of the proceeds from the Biochem stock, much less $4 million, and Bailey's decision to self-help himself to $4 million was never authorized by Judge Paul, his client, or anyone except Bailey. When his disbarment case came before the Supreme Court of Florida, the court had little trouble disposing of Bailey's arguments, noting that by Bailey's own admission, DeBach gave him the Biochem stock neither as a gift nor as an earned fee. Rather, the only other option was that the stock had been given to Bailey in trust to be used for the benefit of DeBach and ultimately the U.S. government. Florida Rules of Professional Conduct 4.1.15 and 5.1.1a require an attorney to keep funds held for the benefit of a client in a trust account, separately from his own funds, and to use those funds only for the specific purpose to which they were entrusted to the lawyer, typically to advance costs and expenses or as a retainer. Here, by commingling and borrowing against the Biochem stock and using those funds to pay his own bills, Bailey violated these rules. The court also rejected Bailey's argument that the money he used was his because it represented his fee in the matter, noting that Bailey's fee had not yet been determined by Judge Paul, who was empowered to award him a reasonable fee following a hearing as required by court rules and applicable statutes. Bailey was not allowed to self-help himself to his fee prior to Judge Paul having determined that fee, and as noted, Judge Paul decided instead to remove Bailey as counsel and award him no fee in light of his conduct. Bailey's goose was also pretty thoroughly cooked on charges that he violated Judge Paul's January 12th and 25th orders and lied about his knowledge of them under oath. It definitely hurt Bailey's claim that he wasn't aware of the January 12th order, given that he had spoken to an assistant United States attorney about the contents of that order on the day it was issued. What's more, 5 days later, on January 19th, Bailey accused the prosecutors of having obtained the order ex parte, which again makes your latter denial that you hadn't known about the January 12th order a pretty tough sell. As to the January 25th order, the court noted that it was served on Bailey by U.S. mail, by fax, and personally by the U.S. Marshal Service. So again, pretty hard to say he didn't get it. For disobeying court orders and then lying under oath about it, the court found Bailey guilty of violating Florida Rules of Professional Conduct 3-4.3, 4-8.4b, 4-8.4c, and 4-3.3a1. Bailey also was found to have violated Rules 4-3.5a and b, which prohibit improper attempts to influence a judge through ex parte communications. The basis for this charge was a January 4th, 1996 letter Bailey wrote to Judge Paul that started, quote, "I have sent no copies of this to anyone since I believe its distribution is within your honor's sound discretion," end quote. One piece of advice: if you're going to send an improper ex parte letter to a judge, don't start out by saying, "I have sent no copies of this letter to anyone." It It kind of highlights your impropriety right there at the start. It wasn't bad enough that Bailey sent Judge Paul an ex parte letter on the eve of DeBach's sentencing, but Bailey used the letter to sell out his client, who had since become unhappy with Bailey due to his mishandling of his assets. In his ex parte letter to Judge Paul, Bailey stated that 1. DeBach pled guilty because he had no defense due to the strength of the case. 2. DeBach chose this course because it was his only option, not in a spirit of remorse or cooperation. Number 3, DeBach was a multimillionaire druggie. Number 4, by consulting with other counsel, DeBach was no longer acting in the spirit of cooperation. And number 5, DeBach's new defense team had interests contrary to those of his client and the court. Bailey sent a second letter to Judge Paul on January 21, 1996, a copy of which was sent to the U.S. Attorney's Office, threatening to seek an order to invade the attorney-client privilege in an attempt to defeat DeBach's position that the stock was held in trust. Because Bailey's letters were sent to compromise his client in front of the sentencing judge, and in an effort to protect Bailey's interest in control over DeBach's assets, the court found Bailey guilty of violating Rules 4-1.6a, 4-1.8a, and 4-1.8b, which prohibit a lawyer from revealing confidential client information and from engaging in conduct that is opposed to your client's interests. When it came time to impose sanctions on Bailey for the violations it had found, the choice of disbarment was pretty clear. The court noted, quote, Bailey has committed some of the most egregious rules violations possible, evidencing a complete disregard for the rules governing attorneys, end quote. Ouch. To be fair, revealing client secrets and using a client's assets for your own benefit, while at the same time knowingly violating court orders and then lying about it under oath, is pretty much the holy grail of ethics violations. And so with that, the great F. Lee Bailey was disbarred in the state of Florida. You might think that is the end of the story, but there's actually quite a bit more to tell, mostly because Bailey had no interest in accepting the Florida Supreme Court's decision, and he sought to avoid his disbarment in Florida from stopping him from practicing law in his home state of Massachusetts, or later from joining the bar in Maine. Despite the many, many differences between Florida on the one hand and Massachusetts and Maine on the other hand, in this case they were aligned on what should be done with Bailey. Bailey's disbarment in Florida led to an order to show cause proceeding as to why he should not be disbarred in Massachusetts in an act of reciprocal discipline. If you've seen the prior installments of this program, reciprocal discipline happens in nearly all cases where a lawyer is admitted in multiple states upon his or her disbarment in one of those states. The standards vary a bit from state to state, but the general rule is that the second state is not required to disbar you in response to your disbarment in another state, but in most cases, the second state will do so in deference to the findings of the disbarring state, unless the disbarred lawyer can show that he or she was denied a fair hearing in that state, that the evidence against him was insufficient to support the imposition of discipline, and in some states that grave injustice would result if the lawyer were disbarred in the second state. Massachusetts follows this general approach, and that is the burden Bailey faced when seeking to keep his law license in Massachusetts following his disbarment in Florida. In rejecting Bailey's arguments, the Supreme Judicial Court of Massachusetts took a workmanlike approach to the charges and evidence, basically following the findings of the Florida Supreme Court and observing that Bailey's conduct also would constitute serious ethical violations under the ethics rules and case law in Massachusetts. Unlike the Arkansas State Bar's treatment of President Bill Clinton, there was no hometown bias in favor of Bailey here, and to the contrary, the court relied on Bailey's notoriety and long career as a lawyer as aggravating factors in deciding to disbar him. Here's what the court said, quote, "We see nothing in mitigation. That Bailey has had a long and highly successful career, as attested by those who submitted letters to the Board of Bar Overseers, urging it not to seek Bailey's disbarment, does not mitigate these multiple violations. Our standards of ethical practice apply to all attorneys, whether they are well known for their victories in high-profile cases or whether they practice law in quiet obscurity. If anything, the fact that Bailey committed such grave misconduct, despite his vast experience as a seasoned litigator, only serves to heighten the seriousness of his offenses. The Supreme Court of Florida determined that Bailey's egregious and cumulative conduct and the absence of any mitigating factors made disbarment not only appropriate, but necessary to fulfill the purpose of attorney discipline. We agree," end quote. It's interesting that experience and fame as a lawyer can be aggregating factors in a disciplinary hearing. I guess there are some benefits to practicing law in quiet obscurity, as the court put it, even if it does make it a lot harder to pay the bills. As we have seen today, reciprocal disbarment by a state of a lawyer disbarred in another state is pretty common, at least among the lawyers who are unethical enough to make it on the Dirty Dozen list in the first place. Bailey's disbarment, however, came with two additional twists that we haven't seen before. First, after Bailey was disbarred in Massachusetts, the federal district court in Massachusetts served Bailey with an order to show cause why he should not be disbarred in that court in an act of reciprocal discipline, pursuant to a local rule that allows the court to impose reciprocal discipline, similar to the statutes that exist in most states. Although Bailey challenged his disbarment by the federal district court, including appealing that decision to the First Circuit, he lost in both courts because the federal standard is basically the same one that applied by the state courts, namely that the federal court will disbar a lawyer in deference to the findings of the disbarring state, unless the disbarred lawyer can show that he or she was denied a fair hearing in that state, that the evidence against him was insufficient to support the imposition of discipline, or that grave injustice would result if the lawyer were disbarred in the federal court. Here, Bailey was unable to prevail on that standard, and he was duly disbarred in the federal court in Massachusetts. This brings us now to number 1 on our Dirty Dozen list, the infamous Joel Steinberg. If you're a millennial, you've probably never heard of Joel Steinberg and are probably wondering how he could top our list of famous lawyers that included a president of the United States, a governor of Illinois, and several lawyers that are household names like Clarence Darrow and F. Lee Bailey. At the risk of spoiling the surprise, Steinberg killed a 6-year-old girl in a crack cocaine-fueled rage, which is pretty much the most horrible thing possible a lawyer or anyone could do. In a strange twist that could only happen to a lawyer, Steinberg actually wasn't disbarred for the killing of this little girl. He was disbarred on a technicality related to his bar application while his criminal trial was pending. His disbarment is an interesting story that we will close with after we describe the horrific crime that Steinberg is infamous for having committed. For any parent, talking about the murder of a child is a difficult thing, so I'm just going to read it to you verbatim from the New York State Court of Appeals opinion that rejected Steinberg's appeal. Quote, "In the evening of November 1st, 1987, defendant and Hedda Nussbaum were at home in their one-bedroom Greenwich Village apartment with their 2 adopted children, Lisa, then 6 years old, and Mitchell, 16 months old. Nussbaum was in the kitchen with Lisa while defendant dressed in the bedroom for his dinner appointment with a friend. Lisa went into the bedroom to ask defendant to take her with him. Moments later, defendant carried Lisa's limp body out to Nussbaum, who was then in the bathroom, and they laid the child on the bathroom floor. Lisa was unconscious, having experienced blunt head trauma of great force, and her breathing was raspy. According to Nussbaum, defendant later admitted that he had knocked Lisa down and she didn't want to get up again. While Nussbaum attempted to revive Lisa, defendant continued dressing. Defendant told Nussbaum to let her sleep, promised to awaken the child upon his return, and then left for dinner. Nussbaum did not seek medical care for Lisa because she believed defendant had supernatural healing powers and felt that calling for assistance would be considered a sign of disloyalty. Defendant returned about 3 hours later at 10 p.m., retrieved a file relating to his oil well investments, and left again. When he came back a few minutes later, Nussbaum urged him to revive the still unconscious child. Defendant declined, explaining that they had to be relating when she wakes up, and he instead freebased cocaine for the next several hours. Finally, at 4 a.m., after Nussbaum's repeated urgings, defendant carried Lisa from the bathroom floor to the bedroom, where her breathing seemed to sound better. Defendant rested his arm on Lisa and continued talking to Nussbaum. At 6 a.m., when Nussbaum left the room, defendant called out that Lisa had stopped breathing. Defendant initially rejected Nussbaum's offer to call 911, but finally acceded when his attempts to resuscitate the child failed. Police and paramedics arrived shortly after being summoned, administered oxygen, and rushed Lisa to the hospital." End quote. At trial, the prosecutors presented evidence that Steinberg had physically abused Lisa several days before her death, and that his knuckles had fresh bruises on November 2nd. Prosecutors also proved that Steinberg had frequently physically abused Hedda Nussbaum, who appeared to have stayed with Steinberg out of fear and based upon the belief inspired by Steinberg that he had supernatural powers. Lisa's condition did not improve, and she was pronounced to be brain dead 2 days later, at which time life support was discontinued and Lisa died. It's just a terrible, awful case, and it establishes what a monster Joel Steinberg was. However, if you needed further proof, following his conviction of first-degree manslaughter, in those days only someone who killed a police officer or who already had committed one murder could be charged with first-degree murder in New York State, Lisa's birth mother, who had given Lisa up to Steinberg in the hope that the lawyer would help place the child with an adoptive family, which Steinberg never did, choosing instead to raise Lisa together with Nussbaum, sued Steinberg on behalf of Lisa's estate, seeking to recover for Lisa's pain and suffering, ultimately winning a $15 million judgment against Steinberg. In challenging that award on appeal, Steinberg made some arguments that will make your skin crawl, including arguing that, quote, because the first grader's death was preceded by, at most, 8 hours of pain and suffering, and a quick loss of consciousness, end quote, the award of $15 million in compensatory and punitive damages is excessive. The New York State Appellate Division, in rejecting all of Steinberg's distasteful arguments, could not help but point out what a monster he was, while at the same time acknowledging that sometimes words fail even those who use the language to render judgments on a daily basis. Here's how the court put it, quote, Steinberg's assertions are entirely without merit. First, for Steinberg to dismiss the 8 to 10 hours preceding Lisa's death as, at most, 8 hours of pain and suffering, or as he alternatively states, a quick loss of consciousness, demonstrates that he is as devoid of any empathy or human emotion now as he was almost 20 years ago when he stood trial for Lisa's homicide. As any parent, and no doubt most adults who have taken trips with young children can attest, the oft-heard question, are we there yet, is a clear illustration that, the more anticipated an event or destination, so seemingly slower the passage of time in a child's mind. For Lisa, lying on a bathroom floor, her body aching from bruises of various ages, her brain swelling from her father's staggering blow, those 8 to 10 hours so cavalierly dismissed by Steinberg must have seemed like eternity as she waited and wondered when someone would come to comfort her and help make the pain go away. The court continued, in urging this court to affirm the punitive damages, the plaintiff appropriately describes Steinberg's conduct as heinous and an inexcusable assault upon a defenseless child. The heinous nature of Steinberg's intentional and deliberate abuse and manslaughter of a defenseless little girl earned him the cognomen Monster almost 20 years ago. Now, the revisitation of the horror that was Lisa Steinberg's life continues to elicit a palpable sense of outrage. We therefore affirm the award for punitive damages. Unfortunately, Steinberg has yet to satisfy any of the $15 million judgment, despite having been released from prison due to a mandatory prisoner release program in 2004 after serving 17 years in prison. So this guy Steinberg is a monster. How in the world did he get admitted to the New York bar? What if I told you that he got admitted without passing the New York or any other state's bar exam? Whatever you think of the bar exam, maybe it exists in part to keep people who just might turn out to be monsters from being lawyers if by some stroke of luck they might trip over this hurdle. So why didn't Steinberg have to pass the bar exam before he could become a lawyer? As the saying goes, the road to hell is paved with good intentions. In 1964, Steinberg had attended 2 years of law school at NYU when the school dropped him for poor academic performance. At that point, although Steinberg had taken 57 of the 80 hours of courses required to graduate, Steinberg had passed only 30 hours of courses. 11 months after leaving NYU, Steinberg joined the Air Force. After serving for 4 years and attaining the rank of first lieutenant, he returned to NYU and graduated in 1970. He then applied to the New York bar, and in his application, sought to take advantage of a special exemption for military veterans that allowed them to join the bar without taking the bar exam if they met certain requirements. Steinberg met most of the requirements, but there was one requirement that he knew he did not meet. After completing an in-approved law school 2/3 of the requirements for graduation, his course of law school study had to have been interrupted by active service in the armed forces. As noted, Steinberg had taken 2/3 of the requirements for graduation, but he had passed just 1/3 of them. And instead of his military service interrupting his law school education, Steinberg was dropped by NYU for poor performance almost a year before he chose to join the Air Force. Of course, Steinberg failed to disclose these facts to the New York State Bar when he applied, but doesn't the bar verify an applicant's standing with his law school? If so, wouldn't the bar have discovered Steinberg's deception? Here's the part about good intentions. In a time when young men like Steinberg were being drafted to serve in the Vietnam War, people were inclined to help military veterans whenever they could. In this case, help came in the form of a letter from the Associate Dean at NYU to the bar. The letter stated in pertinent part, quote, prior to Mr. Steinberg's entry into the armed forces, he completed 4 full-time terms at the law school and then completed 2/3 of the residence credit required for graduation by the Court of Appeals rules. During this period, Mr. Steinberg was enrolled in courses totaling 57 credits, end quote. On its face, this letter suggests that Steinberg would qualify for the exemption, but here's what the Associate Dean wrote in a separate letter to Steinberg dated the same day as his letter to the bar and attached a copy of his letter to the bar. Quote, "You will note that paragraph 3 of my letter does not state in so many words that you had completed 2/3 of the graduation requirements prior to your entry into the armed services," end quote. The Associate Dean acknowledges, quote, "In terms of total hours of credit earned at that time, you had at that point the only 51 credits. You did, however, attend for 2 full years, and you were regularly enrolled in courses totaling 57 credits, as stated in the attached letter." The letter went on, "It thus appears to me that whether or not you meet the conditions of the rule vis-a-vis is a matter of interpretation. My letter to the board contains nothing inaccurate. However, if future inquiry is addressed to the number of hours for which credit had been earned, I should of course have to respond," end quote. The letter concludes, "You may wish to inquire directly of the board, or you may wish to remain silent and hope that they will simply act favorably on your application as it stands." Wow. Of course, Steinberg chose to stay silent and let the bar be deceived, which it was, and he was duly admitted on July 7, 1970. I'm sure the Associate Dean at NYU had the very best of intentions, trying to help a military veteran who had struggled as a law student, but who ultimately graduated from NYU, to gain admission to the bar, but by breaking the rules, he helped a monster become a lawyer. And don't forget about Lisa's birth mother turned over Lisa to Steinberg because he was a lawyer, in the hopes that he would help place the child with an adoptive family. If Steinberg hadn't been a lawyer, maybe Lisa never would have been entrusted to his care in the first place. The final twist to the story is how Steinberg was disbarred. According to a New York Times article, the fact that he did not qualify for the exemption went undetected until Mr. Steinberg was arrested last November in the murder of Lisa Steinberg, the child that he and his companion, Hedda Nussbaum, raised from birth. The flaw in his application was discovered by Harold Reynolds, the chief clerk of the appellate division, who, acting on a hunch, had decided to read through Mr. Steinberg's file. Barely 3 weeks after Lisa's death, the Departmental Disciplinary Committee, another arm of the appellate division, began disbarment proceedings. In reviewing the matter, the appellate division sidestepped the Associate Dean's conduct, stating only that, while the Associate Dean's opinion that the letter does not conceal the truth is certainly open to question, the court found that for the purposes of this application, it clearly reveals that respondent was aware that he was not eligible for the waiver on academic grounds and obviously concealed his ineligibility from the board. Relying on Judiciary Law Section 92, the court found that it is authorized to revoke the admission to practice of an attorney for any misrepresentation or suppression of any information in connection with the application for admission to practice. Having determined that Steinberg had suppressed information about his NYU coursework and separation from NYU in his bar application, the court summarily disbarred him without affording him a hearing. As the court explained, while conceitedly revoking a license without a hearing 17 years after admission is a drastic step, the conclusion is inescapable that respondent withheld material information as to his lack of qualifications for invocation of the Court of Appeals waiver rule. Nor is it unfair to revoke such an admission, even after the lapse of so many years, if the requirements of a high moral character and fitness to practice law are to have any meaning for future applicants. Prospective attorneys are held to a high standard of honesty when examined by this court's Committee on Character and Fitness for admission to the bar. Whatever the importance of any one question or answer or item of information, the overriding consideration is disclosure and truthfulness. Oh, and by the way, this guy's a monster who is currently on trial for the killing of a 6-year-old girl. Okay, so I made up that last part, but judges aren't stupid, and this guy needed to be booted off the attorney role in New York State as soon as possible, and the court knew that no one was going to complain about that result. And with that, we've reached the end of Part 3 of the Dirty Dozen, the 12 most unethical lawyers in the history of the U.S. I hope you enjoyed it. Thanks for watching.